All right, our next presentation is adoption consideration for GALs, and I'd like to say a little piece on my opinion about adoptions. One of the comments from a parent that's on the table is that the GAL treats them like they're a human being. And I really like that because I think that all comes down to we're human beings. And human beings have an innate desire to be loved and have a place where they belong, have a family. No one wants to be an orphan. No one wants to feel alone. Everybody wants a family who loves and cares about them and supports them. And I think socially we need to think about adoption and how we can use adoption as a way of fixing problems. If two people come into a room, similar in age and social status, and one says, I was adopted, and another one says, I was in foster care, those have two very different social meanings behind them. And foster care is oftentimes stigmatizing in a way that adoption is sort of normal in our society. Foster care is not. So I'd like to think about what is in an adoption. An adoption is a way for foster children to hide from stigmatizing glare of foster care. Once you've been adopted, you don't have to talk about that anymore. You can just say, I'm adopted, and everybody's just like, oh, that's great. Adoption can also be a way to stay with your family if you are placed in a kinship adoption. Adoption can be a way to cement a bond between foster parents and the children that they live with. But I think that adoption is more of a dream for a lot of children in foster care, a way to belong, a place to belong, a family of their own. So, I would just like to say that I won the foster care lottery. I got wonderful, wonderful parents, siblings that treat me like I've always been there, but I'm not adopted. And even as an adult, it would mean so much to me to be adopted. And I think that as GALs, we're the guardians of adoption. If the child wants to be adopted, the GAL is kind of the one who can make or break that. And I think as we talk about adoption and as we talk about legislation and policy reform, we need to protect adoption tax credits. We need to protect the things that bring in adoptive parents. In fact, I think adoption from foster care should be free, right? If it was free, how many foster children do you think would be unadopted? Not that many. I mean, I think that financially, if you want a child and it's a matter of, it's gonna cost a lot of money, a lot of people don't do that. I'm not adopted because I wouldn't want my foster parents who would adopt me to spend that kind of money on me. So, who thinks foster care adoption should be free, right? So as we discuss adoption-related legislation, please consider how we can make adoption a reality for more youth, how we can help these youth achieve that dream. Up next, we have two attorneys who are very experienced in adoption law, Seth and Tim Irick, who will be talking about adoption, and I hope that you all can really think about the kids on your caseload who could be adopted, who are adoptable, and try and make that a reality for more kids. Thank you.
Good morning. First of all, it's a pleasure to be here today to talk to you about adoption and some considerations you should think about in your practice as a guardian ad litem. Just real briefly, in terms of my background, I just want to share with you for the first 8 years of my career, I served as a guardian ad litem at the Rocky Mountain Children's Law Center and did a lot of child welfare and adoption cases. Over the last 14 years, I've had my private practice, which is specialized in adoptions, particularly private adoptions and also public adoptions. And what I want to do today is draw from those 22 years of experience, both being in your shoes and also in private practice, and try to educate or raise some issues that I think are important for guardians ad litem. In terms of today, we're going to generally cover a number of topics. That's going to include adoption subsidies, discussing custodial adoptions, talking about putative birth fathers and the importance of naming and identifying and serving putative birth fathers, so ultimately termination of parental rights and adoptions are not suspect and they can't be challenged down the road. Then Tim's going to talk about a very timely topic, the baby Veronica case that just came down from the U.S. Supreme Court about a month ago, and the implications it will have on everybody's practice as it relates to termination proceedings involving Indian children. Tim will also talk about the standards for contested post-termination and adoptive placement hearings. I would ask that you hold your questions until the end. We will save a few minutes at the end for your questions. If you disagree with something that we say, don't jump up and down until the end, okay? Thank you. In terms of adoption subsidies, I want to spend a few minutes on that because I think it's very, very important for guardian ad litems to be involved in helping to secure an appropriate subsidy package for your child clients. From my perspective, having done well over 1,500 adoptions, adoption subsidies are often critical to ensuring that the adoption maintains in the future and that the children's needs are met post-adoption after everybody leaves the dependency case. If you look at the mandates for a guardian ad litem under 19.3203, you look at the case law in the interest of MN, the interest of MCP, guardian ad litems clearly are charged with finding an appropriate adoptive home if reunification cannot be achieved. And I would argue as part of finding that appropriate home is to ensure that the child has a support through adoption assistance that he or she is going to need in the future. You might say, well, what is my role as a guardian ad litem when adoption subsidies are at issue? I think there's really 5 roles that you can play. The first is helping to educate the prospective adoptive parents, whether they be relatives or foster parents, about the availability of this program and what it consists of. Secondly, referring prospective adoptive parents to independent private counsel to represent their interest. And in our practice, we represent foster parents and relatives throughout the state in securing appropriate adoption subsidy packages. Third, ensuring that the child's evaluations are updated and complete. So when we go into adoption subsidy negotiations, we fully understand what those needs are, what services are going to have to be put in place to maintain that placement, and what is it going to cost the family to provide those services. And you're in a unique position in juvenile court to ask the juvenile court judge to order various evaluations so we have that information and it's relevant and timely. Fourth, I would urge you as a guardian ad litem to participate fully in the negotiations with the county. You bring a unique perspective to the table. You represent the child's interest. That perspective needs to be heard at the negotiation table with the county. Finally, when an appeal is filed with the Division of Administrative Appeals, if the parties can't reach an agreement, I would urge you to intervene in those proceedings and litigate on behalf of your child client. After 22 years of practice, having represented lots of foster parents and relatives and other prospective parents, I am a firm believer that advocacy results in a good outcome for kids. There was a study that was done in the early 2000s by Dan Pollack. He's a professor at Yeshiva University. And what he did was he looked at all of the states in terms of how equally they distributed adoption subsidy payments. And you know what he found out? Colorado ranked last in equality. So that tells me that when prospective adoptive parents have advocates, when the child has an advocate, in my experience, you're much more likely to get a very positive outcome than without that sort of advocacy. In terms of general considerations regarding adoption subsidies, I just want to point out a few things that many of you hopefully do know but perhaps don't know. When we talk about adoption subsidies, there are 2 programs involved here in Colorado. One is a federal Title IV program, and one is a state county-only program. Roughly 80% of your children that you represent will qualify for a federal 4E subsidy. And I'm not going to go through the eligibility requirements right now because it's beyond the time that I have. But basically, if a child qualifies for a Title IV-E subsidy, there are various benefits associated with that in comparison to a state county-only subsidy. For example, with a federal subsidy, once the subsidy is set, it cannot be changed without the concurrence of the adoptive family. That is, the adoptive parents are assured that whatever rate is established, it cannot be changed in the future without their agreement. Secondly, with the Title IV-E subsidy, the Medicaid that is provided is transferable to every state. So when that family, or if that family moves to a different state from Colorado, that Medicaid is going to follow the child. With a state county-only subsidy, there are certain states in the District of Washington, D.C. that do not recognize and will not provide Medicaid if that family moves. So by all means, make sure if your child client qualifies for a 4E subsidy, that's what is provided. Secondly, several years ago, the state delegated to the counties to develop their own subsidy policies. So now we have roughly 64 different subsidy policies, and it's important when you're involved in these cases that you obtain the most recent, relevant, timely subsidy policy that the county has issued. And I will tell you that there's vast discrepancies between and among counties in terms of how lucrative or how restrictive those policies are. You can access those policies on the State Department of Health and Human Services website. I would still urge you to get the most recent version because they're constantly changing at the county level. Third, think about the fact that the county must make, quote, a good faith effort to negotiate an adoption assistance agreement with the adoptive parents. So when we come to the table, we mandate that the department negotiate in good faith. And that involves a face-to-face meeting. It involves an exchange of information, an identification of what the child's needs are, what the family circumstances are, what the ability of the family to secure services free of charge in the community, because that's what we're going to look at in these cases. Realize that there's 4 benefits available under the subsidy program. Monthly maintenance payments, which is comparable to the foster care rate that the family is receiving. We're going to talk a little bit more about that in a second. It can also involve reimbursement for other case services. It can involve non-recurring adoption expenses reimbursement, such as attorney fees, transportation cost, home study fees, up to $800 per child. And it can also and will involve provision of Medicaid, regardless if it's a Title IV-E or state-only subsidy. In terms of monthly maintenance payments, realize that there's 3 types of payments that can be made to a child. One is, and typically this is the one we're seeking, is a long-term subsidy. A subsidy is going to continue throughout that child's childhood. And I want to read you the state regulation that governs a long-term subsidy and the federal policy interpretation. State regulation says that a long-term subsidy is appropriate where the family's financial situation precludes adoption and is unlikely to change, or when a child's needs take an excessive toll on the family's financial and emotional resources. Then federal law provides that the payment, quote, should combine with the parent's resources to cover the ordinary and the special needs of the child projected over an extended period of time and should cover anticipated needs. What's important about federal law is it says that when you give a federal Title IV-E subsidy, it must cover the ordinary and the special needs of the child. I will tell you, in my experience in working with counties, many counties have taken a perspective that the subsidy should only cover the special needs of the child. And in fact, they put that in their policy. That's in direct contravention of what federal law provides, and it's not permissible. So keep in mind what the standard is for a long-term subsidy. In terms of long-term subsidies, what most counties have done in the last 5 years or so has developed a 2-tiered system of reimbursement. That is, they provide a higher level of reimbursement for foster care and a much lower reimbursement for adoption subsidy payments. Prior to 2006, we had argued that that process was unlawful, and in fact, I was involved in a case out of Oklahoma, Laws v. State of Oklahoma, where the Court of Appeals there struck down that 2-tiered system as being in violation of federal law. In 2006, the Federal Department of Health and Human Services issued a policy statement that permits states to now limit the maximum subsidy rate to less than the maximum foster care rate. So it seems to be that that 2-tiered policy is in fact now permissible. So when we approach these cases, and I urge you to approach these cases the same way, is to argue for separate reimbursements for medical or case social service expenses. So Colorado, like many states, allow for states to provide for services that are not covered through Medicaid. So if you look at the regulations in Colorado, it provides that the counties can provide under the Adoption Assistance Program orthodontia, eyeglasses, prescribed medications, speech, occupational, physical therapies, special medical equipment, psychological exams, outpatient therapy, respite care, and transportation, just to name a few. In our practice, we have been able to negotiate and procure assistance for respite care for families in addition to the basic rate, trauma therapist reimbursement, summer camp, updated assessments. I recently had a case where we got a defibrillator provided for a child who had a heart condition that was not covered by Medicaid. I've had cases where we've had accommodations made to the home, such as ramps built for wheelchair accessibility and lifts for vehicles. So again, it's another way to access additional services for your kids. I want to just mention the federal adoption tax credit that was just mentioned by one of our youth. In January 1st of 2013, the President signed the federal adoption tax credit to be made permanent. It is a significant benefit for families generally who adopt, but also for families who adopt special needs kids. So for families your families who adopt, who make under $195,000 a year, they will be able to obtain a flat tax credit of $12,970 per child. It's regardless of what they spend. If there's 2 kids, then you double that credit to $36,000. I recently had a case out of Boulder where we had 4 kids and the credit was $52,000. I want to point out that this is not a deduction. This is a dollar for dollar credit, so it reduces the adoptive parent's federal tax liability. And if they can't take it in year 1, they can roll that credit over for a period of 5 years. Make sure that the families that you're working with know about this tax credit and claim the tax credit. Another program I just want to mention that's aside and separate from adoption subsidies but's relevant is the Chaffee Foster Care Independence Program. So when you're dealing with older youth, hopefully who realize their dream of adoption, think about this program, because this program provides kids who are adopted at an older age assistance with post-secondary expenses. And the key is, if a child is adopted after the age of 16 and they get their GED and they go to college or vocational school, they can get up to $5,000 per year through their 23rd birthday. So in your practice, if you're dealing with older children, I just had a case up in Larimer County where we had 3 siblings, one of whom was about 15 and a half. We delayed the adoption until 16 to make sure that at least 2 out of 3 siblings qualified for this program. In terms of resources, I've listed a few that you can generally go and review yourself, but the North American Council on Adoptable Children has an excellent website on subsidies. The Federal Department of Human Services has issued a Child Welfare Policy Manual, Chapter 8, which is critically important in this area. State statutes and regulations, obviously, you need to review. And the one case here in Colorado, the SAP case, is the only case dealing with adoption subsidies in the state of Colorado. Now, I want to switch gears now and change topics and talk a little bit about custodial adoptions. And I really want to focus on the situation where a dependency case is open and the parents and the county have come to an agreement to establish an APR or a guardianship arrangement in lieu of pursuing an immediate termination and adoption. And obviously, as a representative of the child, you're going to need to sign off on that stipulation or not. We had a youth just talk a minute about the dream of being adopted. So obviously, there's psychological benefits associated with adoption. Aside from the psychological benefits, when you're considering whether to sign off on a stipulation like that, perhaps as a means to later adopt through a custodial adoption, think about the benefits that a child is not going to obtain through an APR or guardianship in comparison to an adoption. So, for example, I've just listed a few here. A child's not going to receive inheritance benefits through their guardian. They're not going to receive Social Security death benefits if their guardian dies. They're not going to receive military benefits if their guardian is in the military and perhaps dies. They wouldn't be entitled to any sort of critically important military benefits. They won't be able to be on their parents' health insurance, at least the guardian's health insurance, through 26. They won't be able to initiate a workers' compensation claim, a wrongful death claim. And the adoptive parents, the legal guardians, won't be able to claim an adoption tax credit. And in many of these APRs and guardianships, there is very little, if any, financial assistance available. Unlike adoption assistance, which is routine among all 64 counties, the kinship and guardianship program, in my understanding, is now only available in 4 or 5 counties. So it's not readily available, so there's going to be limited financial resources for the legal guardians. Another thing I want you to realize when you're considering whether to accept that guardianship or APR is that you may be subsequently jeopardizing the child's eligibility for adoption subsidy. So what's happened is there's been a number of litigated cases throughout the country. Two cases that came out of Iowa and the Arkansas Court of Appeals have said that when a child enters a dependency case and later becomes a legal guardian, a child of a legal guardian, and that family later seeks to adopt, that child is no longer eligible for adoption subsidy. And the reason is those states have read in a requirement that at the time of the adoption, the state must be legally responsible for that child. And because we have a relative or foster parent who has now received legal guardianship or custody in the interim period, that child is no longer eligible for assistance. I will tell you that the Pennsylvania Supreme Court and the West Virginia Supreme Court have ruled the other way and have not read in the requirement that the child has to be in legal custody of the state at the time of the adoption. So again, we have various jurisdictions ruling differently, and in Colorado, there is no case law on this point yet, but I will tell you that it's something to consider in your practice, and the family that takes in an APR or guardianship should be well advised that if they later pursue a custodial adoption, that the child may not be eligible for adoption assistance. I want to just review the custodial adoption requirements, because I think it's important for families who accept these arrangements to be fully advised about what it's going to take in the future if they want to adopt. And I know from my experience, we see these cases really for two reasons where APRs or guardianships are established. One is because you want to allow enforceable contact between the child and their birth parents, and I understand that, especially with older children. But I also see cases where it's the path of least resistance, that it's going to be a tough termination case, everybody's in agreement, and we're just going to settle for a guardianship or APR. And I think in those cases, again, you need to look very clearly and closely at, is this arrangement going to serve the child's best interest? And later on, will this child ever be available for adoption? And so here I've listed the requirements for a custodial adoption. Very generally, it requires that you show abandonment for a period of 1 year or more, or failure without cause to provide reasonable support for a period of 1 year or more. You also have to show that there's a current order of APR or guardianship in place. You have to establish that the petitioners have had physical care of the child for a period of 1 year or more, that the adoption's in the child's best interest, and that if the child's over the age of 12, they have to consent to the adoption. In terms of abandonment, I've listed here the cases that are relevant to defining what is abandonment when you're pursuing a custodial adoption case or a step-parent adoption case. Definitely review the case law if you're going to be involved in these sorts of cases. Similarly, I've listed the relevant cases dealing with the parent's lack of providing reasonable support for a period of a year or longer. I don't have time to go over all these cases, but I did want to list them in your materials for your reference later on. Finally, the other consideration that you should be thinking about whether to accept an APR or guardianship is what happens if the birth parents later want to have the child returned to their care. And in those scenarios, realize that the Troxel constitutional protections apply to a birth parent who has not been found to be unfit. So we've had two recent cases, the GELS case and the BRD case, the former coming from our state Supreme Court, the latter coming from our Court of Appeals, that said, when there's a stipulation of guardianship or APR and there's no finding of unfitness, and the birth parents later seek to recoup their child, a presumption will be placed on the fact that a presumption should be applied to follow what the parents want and their wishes, and that the burden of proof is now placed on the third party to dispute that. If you're involved in these cases, and in fact you accept a stipulation, I would urge you to put in the factual findings in the stipulation, if it's relevant and true, that the parents are either unfit or not able to parent. Because if it goes in the agreement, then the Troxel constitutional protections go away. Secondly, if you enter into an APR order, I would hope that you're putting in there a child support order, not only because it's the parent's responsibility, but secondly, if the relatives or prospective adoptive parents later on want to pursue a custodial adoption, there will be a factual basis to argue later on that the parents have failed without cause to provide reasonable child support. Finally, I want to talk briefly about putative birth fathers. A putative birth father is basically a father who's alleged to be the biological father of the child and has no presumptions under the UPA here in Colorado. I want to talk about putative birth fathers because it is so important to make sure that you identify and you personally serve any and all potential fathers to obviate the concern that the adoption or termination order can be unraveled down the road. There have been two recent cases in the private adoption context that I want to bring to your attention. The first of which I was involved with. It's my case. In re JMA, and the other case is in re CLS. The facts of these two cases are almost analogous. Basically, in both of these cases that went to the Court of Appeals, the birth mother elects to create a voluntary adoption plan. She lies about the identity of the birth father. In all her affidavits to the court, in her testimony, she doesn't disclose who the actual father is. Ultimately, the court proceeds and terminates on any and all unknown birth fathers because she didn't name anyone. She committed fraud. Subsequently, the actual father learns about the adoption plan and comes forward and claims that he wants to parent the child, and he seeks to set aside the termination order as it applies to him. Quite a few years ago, I had written the statute of limitations that said that there's a 90-day period to attack a termination order in a private adoption case. The Court of Appeals said we don't care about the statute of limitations. When fraud is committed, a birth father has a constitutional liberty interest to try to raise his child and can come back at any time and seek to set aside the adoption. So now we have a situation where we don't have finality if we don't name and personally serve the appropriate birth father. I will tell you from a personal perspective, I think our Court of Appeals has completely missed the boat on this. I'd love to get a case up to the state Supreme Court because in the U.S. Supreme Court cases dealing with Lear v. Robertson, which you're probably familiar with, and a whole line of cases, the U.S. Supreme Court has said that unless a birth father seizes the opportunity to parent, he has no veto power over a birth mother's adoption plan. Well, you might say, well, what relevance does this have in my dependency practice? And it has a lot of relevance. There's a case right now, and I'm just going to point out the case of interest of SD. It's a case that originated from the Rocky Mountain Children's Law Center. I believe it's Chris Henderson's case. Chris, you here? Yeah, there he is. Okay. So just real briefly, facts are very analogous to what I just described. In the SD case that's pending before the Court of Appeals, the birth mother names Father 1 as the father. The court authorizes service by publication as to both him and John Doe because he wasn't found. Termination occurs as to any and all unknown birth fathers. Approximately 15 months later, after this child has been in placement and EPP guidelines have run, the actual birth father comes forward and actually contacts Chris and says, I want to parent this child. Now, what's unique about this case was that it was this guy who initiated the referral to the State Department of Human Services. It was this guy who was actually involved in helping to parent this child early on in the child's life. And it was significant that this man also had a relationship with the mother. Notwithstanding, he had kind of de facto notice of this proceeding. He argued that the termination order should be set aside as it applied to him. The Denver Juvenile Court, in fact, did set aside the termination order as it applied to him, created a treatment plan, and basically delayed permanency for this child. And on appeal, Chris and the Rocky Mountain Children's Law Center are arguing that under these facts, this father should not have a constitutional due process interest to raise his child. A couple points I want to make. As a guardian ad litem, you can make a difference to ensuring that proper identification and notice of birth fathers is done. We do it all the time. We represent 6 adoption agencies, and we go out of our way to try to name and identify and serve birth fathers. We interview birth mothers, and we go over the time of conception, within 45 days of conception, who might have had sexual intercourse with this woman. We require the birth mother to sign an affidavit of paternity, identifying any and all potential birth fathers along with background information or contact information. We sometimes require DNA testing to be done to confirm paternity. We routinely hire investigators to locate and personally serve all potential birth fathers. So if you're in a situation where the department says we can't find this birth father, go ahead and have the court authorize or the OCR authorize the hiring of an investigator to track these guys down. Finally, if a birth mother says, I don't know who the father is, let's say I was intoxicated, I was at a party, I had sexual intercourse with a number of men, we require her to come into court, testify under penalty of perjury, under oath, about all the information about the situation. And you'd be surprised how many times we tell the birth mother that she needs to come into court that she'll reveal additional information for us to identify and serve the potential birth father. I'm going to stop there and turn it over to Tim. Nope. There you go.
Good morning. So we can't talk about adoption either in the child welfare arena or in the private arena without talking about the Indian Child Welfare Act. And I'm not going to talk about the entire act, but I'm going to talk about the new case that just came out at the end of June from the U.S. Supreme Court. Technically, it's called the Adoptive Couple v. Baby Girl. In the newspapers and all throughout the media, it's known as the Baby Veronica case. So in a nutshell, the facts are this. An adoptive or a birth mother in South Carolina, she and her then boyfriend decided, she got pregnant, they broke up, and she decided she was going to place this child for adoption. The agency knew that the alleged birth father may have had Cherokee heritage, so they gave notice to the Cherokee tribe. Throughout the process, birth father indicated his agreement to the adoptive plan, and then right before or right after birth, he signed paperwork agreeing to the adoption plan. A day after he signed paperwork, he decided he no longer wanted to pursue the adoption plan. He contacted an attorney, and they tried to undo his relinquishment paperwork under the protections, the higher protections afforded to Native American parents through the Indian Child Welfare Act. And after almost 2 years, this case wound its way through both the trial court in South Carolina as well as to the South Carolina Supreme Court. And the courts in South Carolina denied the request to terminate his rights. They denied his request based on the fact that the adoptive family was not able to, first, demonstrate that active efforts had been made to provide remedial services designed to prevent the breakup of the Indian family. Language you hear all the time as part of ICWA cases through the child welfare system. They also said, you can't involuntarily terminate parents' rights in the absence of a determination that beyond a reasonable doubt, including testimony of qualified expert witnesses, that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. The court also went on to say that even if you could meet those factors, the placement preferences under the Indian Child Welfare Act apply. Meaning, first you have to look at a family member, then a member of a tribe, and low on the list is this adoptive family. So that wound its way through the South Carolina Supreme Court, and that's what they agreed, that this termination could not have continued, could not have occurred. So that went to the U.S. Supreme Court. And as it's, let me see if I make sure how to do this. And the Supreme Court looked at this case, and I will tell you, up until this opinion, most courts, at least particularly in Colorado, when they've looked at these statutes, particularly the first one, when we talk about active efforts, they've looked at the meaning of, well, what are active efforts? Is it just different than reasonable efforts? U.S. Supreme Court did something very unusual. They ignored that definition, and they looked at the concept they looked at the context of breakup of the Indian family. And what they looked at, their interpretation of 25 U.S.C. 1912d was, when a parent has already abandoned the child and the family has already been broken up, this statute is inapplicable. This section is inapplicable. They didn't touch upon active efforts. Then they looked at the next section. And they looked at, rather than what findings need to be made beyond a reasonable doubt, they looked at whether or not this birth father, who prior to birth had abandoned the child, and they said when a parent has never had continued custody or never had custody, again, this section is inapplicable. Then the U.S. Supreme Court went beyond that. And they went to say that even if you were able to terminate, these placement preferences don't apply when a viable family has not actually come forward and petitioned for an adoption. So we don't talk about placement preferences in theory. We talk about them in actuality. And in this case, even though there are placement preferences, because a member of the family, biological family, never came forward, and because a member of the tribe never came forward to adopt, these placement preferences are inapplicable. This was really, I think, of the three sections the U.S. Supreme Court talked about, was probably the most surprising, at least through the practitioners that have followed this case from its inception to its finalization with the U.S. Supreme Court. This section was very surprising. Now, obviously, this case deals with ICWA in the context of a private adoption. But I believe this case is even more applicable in the context of child welfare cases. Because how often does it arise where birth mother has a case filed because of something she did, and then you find out who the father is, and the child may have been in care now for 1 month, 2 months, 12 months, 15 months, and like the example of the case Chris Henderson dealt with, father comes out late in the case, we find out who dad is, and all of a sudden they come out and they say, this dad has Native American ancestry, and ICWA applies. I believe this U.S. Supreme Court, and I think practitioners across the nation believe, this ruling completely shapes and affects how ICWA is applied, particularly in the child welfare arena. Because if a father, through no fault of government intervention or through no fault of other essentially private entities, if he on his own or she on her own has abandoned the child or has never been a custodian, these preferences don't apply. Now, it still begs the question is, what does custody mean? In this case, the U.S. Supreme Court seemed to focus on the fact that he was never a custodial parent. He never had any court orders saying that he was a custody. He never had any kind of custodial rights. But in the context of Colorado, obviously, we don't really use the word custody anymore. So it still begs the question as to what does continued custody mean in terms of this applicability? If a father may not be granted any decision-making, but he has visitation, is that considered continued custody? Or likewise, if he was involved prior to the birth of the child and immediately after the birth of the child, but at some point before your involvement with the dependency and neglect case, if he then abandons the child, does the ICWA statute, does this section apply? So the takeaway with, and likewise, at what stage, when we talk about the third criteria, the U.S. Supreme Court made it very clear that when you're looking at placement preferences upon termination, at what point do those placement preferences trigger? So say, for example, rights are terminated, and right on the cusp of the adoptive family's or the foster care relative's placement, a member of a tribe comes forward, or a member of the family comes forward and says, I want to adopt. At what point do these placement preferences get triggered to the point this section now applies? But the takeaway from this case is that our concept of the Indian Child Welfare Act and how it's applied has completely changed. When we have birth fathers that come forward late in the case and they've never had custody of a child, they never had contact with the child, or the family was long broken up prior to the government's involvement and your involvement, to what extent does the Indian Child Welfare Act provide heightened protections to these fathers? Now, I want to be clear, this still involves, the tribe still has independent rights. The tribe still could come forward and independently ask for the case to be transferred to the tribal court. The tribe still has rights to put forward, and obviously the tribes are well aware of this case. They still have a right to put forth a family member or a member of a tribe to say, we want to be an adoptive placement. But this case absolutely changes the landscape of how the Indian Child Welfare Act is applied. So I encourage you all to read this case, and the takeaway is this opens the door for significant litigation. I will tell you from, prior to joining Seth last year, I was the director of the Rocky Mountain Children's Law Center for a number of years. And I will tell you, I think particularly in Denver Juvenile Court, there was case after case of ICWA cases being overturned because of the court's failure to follow those regulations. And so what we saw And I think all of us, probably throughout the state, saw this, because all of us, I'm sure, have had situations where the Indian Child Welfare Act is triggered. As soon as we hear that it's potentially an ICWA case, our senses heighten. We're afraid to push it because it just screams, appeal me. Unfortunately, sometimes to the detriment of children, particularly when kids have been in placements for a number of years, and all of a sudden these placement preferences are triggered, and we're looking at removing a child who's been in a home for 3 or 4 years to place them with someone they've never met before, simply to follow the preferences. This case opens the door to litigate these truly from a best interest standpoint, and opens the door to litigate these issues that frankly had never really been litigated before. I will tell you the side note. About 2 weeks ago, based on the U.S. Supreme Court's decision, this case was remanded to the South Carolina Supreme Court. And by way of history, when this child had been with the adoptive family for 27 months. Based on the Supreme Court's ruling, the child was removed from the adoptive family and placed with the birth father, where he stayed for 2 years. Based on the U.S. Supreme Court decision, the South Carolina Supreme Court took a very decisive approach, and they said, we are ending this litigation now because we made a mistake and father's rights should have been terminated. We are terminating his rights, and we are sending this child back to the adoptive family. Legally, that makes sense. As practitioners, you could all imagine the effect this whole mess essentially had on this child. And it still raises the issue that when we're dealing with children, appellate remedies, although they might be legally successful, wreak havoc on children. And so I encourage you guys to read this case. I went over, there's significant dissent. It raises a lot of personal and professional issues about really why the Indian Child Welfare Act was enacted and why it's applied and how it should be applied. Read this case. It's very important, and without question, it will impact your practice, and it should impact your practice. So with that, I'm going to change gears. So in my practice, both at the Children's Law Center and now with Seth's office, I represent a lot of foster parents and relatives throughout the state. I was involved in the case before the Supreme Court in which the Supreme Court determined that foster parents have a right to fully participate in termination trials. So the big question that we are often faced is with this hypothetical that I'm sure you guys have seen in some various forum. The child has been in foster care for a length of time, whether it be 15 months, 9 months, 2 years, and a family member that may or may not have been known to anybody comes forward and says, we are an available placement. And the court sets it for a hearing. So the question is, we are having a hearing. And for the purpose of this, we'll say that hearing will occur after a year, which for children under 6 means that EPP timeframes would have run. What legal standard do you apply at that hearing? This is a rhetorical question for now. I think historically, when I first started at the Law Center maybe 8 years ago, I think in my first months there, I'd handled a couple of cases, and everything I saw and everything I did flowed from 193605, section, I believe it's 3, where the court looks at a bunch of different factors, and the court makes a determination as to what he or she believes in the child's best interest. And these are the factors that the court looks at, whether the current placement is a potential adoptive placement, how long the child has been there, what are their attachment needs, what are their psychological needs, what's the impact on the child if he or she is removed from this placement. In effect, this is a discretionary standard, where the court gets to weigh all these factors, determine which of these factors the court believes is the most appropriate, and then the court makes essentially a subjective determination as to what he or she believes is the child's best interest. And I'm sure that's probably a lot of you have had these hearings, where that's what best interest is about. Or conversely, sometimes courts look at the permanency statute. And under 1937-025, the court could have made some determinations that if termination hadn't been filed, are ready, a court could say, based on the length of time, I'm asking the department to show cause as to why a determination or motion shouldn't be filed, and we shouldn't proceed down that path. Or the court can make a finding that, based on the length of time the child's been in foster care, this child shall not be removed from that home because of the emotional attachment and the harm to that child if he or she is removed. Again, this is all may language. The court may do this. The court may do that. And when we talk about appellate remedies for kids, discretionary standards are really hard to appeal. And particularly sometimes when you're in front of a judge that may have a particular slant toward foster parents or a particular slant toward family members, sometimes same case, same facts gets handled completely differently in various counties. But that's a lot of ways how I've done a lot of trials under this standard where a child's been in care, EPP is run, and this is what we're looking at. But then we look at the EPP statute. And the EPP statute, I believe, is frankly the strongest piece of legislation in the Children's Code. And I say that for a couple of reasons. One is that the language is strong. The child shall be placed in a permanent home within 12 months, unless the court determines it's not in the best interest of the child at that time. Now, I will tell you, I've been in court, and I've been in staffings or drug court staffings where the judge is there, and it's these informal meetings that may or may not be on the record. And I've heard parties say, and I was guilty of this myself at some point, we say, well, Judge, we're asking you just to make a good cause finding to extend EPP guidelines, or just find it's in the child's best interest. And this is typically where many of us would stop reading the statute. Make a discretionary best interest finding, Judge, and we will go beyond the 1-year time frame in terms of placements. But if you keep on reading the statute, the EPP statute is the one place in the Children's Code in which best interest is actually defined. And essentially says that in determining whether a delay is in a child's best interest, you have to make these findings by clear and convincing evidence. And these findings are limited to 2 circumstances. One is that, frankly, a permanent home is unavailable, and you've all tried to find one. The second is that the child's needs and conditions are such that he or she is unlikely to have a permanent home. Then it goes on to say that when you're having hearings and this time frame has expired, you have to apply a different legal standard at these permanency hearings. It's no longer preponderance. You have to be looking at clear and convincing standards of evidence at reviews. So if you're doing a permanency hearing beyond a year time frame, this is what's supposed to be applied per the EPP statute. Now, this isn't a new statute. I think it's one that, frankly, as a state, we've readily ignored. Maybe about a year and a half ago, I was at a best practice court in one of the metro jurisdictions. And Judge Lowenbach, who's a retired chief judge from Weld County, was leading this session. And he asked a group of judges, practitioners, departments of human services, and he asked judges and everybody else here, who has ever made these findings? No one raised their hand. In fact, the judges commented, like, well, I don't really ever read that statute that closely. And it was kind of a head scratcher. That is until this AC case came out. Now, this is a case that came out of Denver Juvenile Court, and it had to do with a situation where Department of Human Services, parental rights were terminated. There were some allegations that the foster parent, the foster mother, who was the presumed adoptive placement, was having some mental health issues, and the Department of Human Services swept in and removed the child. And there was a lot of backstory about what notice was given to the guardian ad litem and some other issues. But the fact remained the child was removed post-termination from a family that had said, we will adopt, and rights were terminated, and it was post-EPP. So the question is, when you remove a child in that situation, what standard applies? And I think the issue that went up to the Court of Appeals and ultimately the Supreme Court had to do with what constitutional rights do foster parents have. The issue about the legal standard, to my understanding, wasn't really briefed or raised in the legal argument. But but Judge Furman, kind of on his own, talked about what's the proper legal standard when you do these hearings. And what Judge Furman wrote was, listen, if you're going to be removing a child from a home that is a potential permanent placement or a permanent placement, potential adoptive home, you have to show by clear and convincing evidence that either that home is unavailable or has become unavailable, or the child's needs and conditions make it unlikely this child's going to have a successful permanent home. Now, some judges have now scratched their heads like, we're not sure what this means. But in the context of these post-termination placement hearings, judges around this state, and I've been successfully arguing this to the state, is that this statute means, and this interpretation, which frankly just repeats what the statute says, means that when you are doing a post-placement termination, a post-placement custody hearing, or a post-termination placement hearing, rights are terminated, and there is a debate after a year as to with whom should this child be placed. This is the legal standard. It should not be a judge is using a discretionary standard to look at a bunch of factors in determining what he or she believes in a child's best interest. Rather, the court should be looking at whether or not this adoptive home, this placement first and foremost, is a potential permanent home, meaning are they willing to adopt? And if so, then you have to show that somehow they've become unavailable in order to remove this child, or the child's needs and conditions are such that this permanent home is unlikely to be successful, or any placement's unlikely to be successful. Now, I will tell you, I've probably made this argument in about 10 different jurisdictions throughout the state. One judge last week, when we talked about just arguing about the legal standard, was a judge on his own said, I have that AC case. He's like, are you going to talk about the AC case? He's like, I have that case here at my bench, and this judge says, I think this is the most important case that has come out recently from the Court of Appeals, and I have it on the bench. Now, I say this with the caveat that I know that this maybe perception and this standard is somewhat hard to swallow or even controversial because it's not discretionary. When I've made these arguments, I've heard counties argue that and say, well, where a child just happens to be should then not be the adoptive placement. My argument is that, frankly, kids shouldn't just happen to be anywhere. And I mean that seriously. I think sometimes we look at these cases and we forget the fact that, frankly, this year time frame goes by pretty darn quick. And so if you read the statute, and I want to be clear, I represent relatives as well as foster parents. So I've been on both sides of this argument. The law is very clear. Without question, particularly early on in the case, there is a preference to place kids with family. There is also, both in the statutes as well as most of the jurisdictions' best practice plans, we should be looking early and often for family members. We shouldn't be getting at a point where in an EPP case, we are at 15 months, 2 years, 3 years, arguing about with whom should this child be placed. That to me is what this EPP statute means, is that when Judge Furman wrote this is what his interpretation is, I read that to say, frankly, EPP really means what it says, is that a child shall be in a permanent home. Linda? Shall be in a permanent home within a year. And if you're in a hearing afterwards where a year has passed, this is the standard. So with my calculations, I believe we have 10 minutes left. So with that, I think Seth and I are going to sit at the table here and answer any questions, or you can yell at us or tell us how you disagree. Any questions?
Should I let you sit down, or?
Who are you asking, Seth or I?
I'm going to start with Seth and then get to you, Tim, if that's okay. Seth,
Yep.
You talked about us participating in administrative actions after we and the foster parents are not happy with the subsidy. To a certain extent, in the new adoption or proposed adoption, we're strangers. We are not guardians ad litem in that case. I suppose we could ask to become guardians ad litem in the case, but there's no adoption yet, hasn't been filed yet. Is there standing somehow in the adoption process so that I can go in and insist on showing my face at the administrative hearing?
You know, I guess I would urge you to argue the MCP case, which is 1988, a case where the department found a adoptive home for the child, and the guardian ad litem sought information about that family to assure himself that this was an appropriate and suitable family for this child. And in that case, the Court of Appeals held that the guardian ad litem has access to the name and addresses of the prospective adoptive home. So I don't think the representation necessarily, ends at the time that the child is then pursuing, an adoption.
And that's great, because we're aggressive about that. Those adoptive families need to have as much money as they possibly can. Thank you. And I really appreciate your comment about when we do APRs, we need to get the unfitness statement in the order that goes up to the district court, or else when someone objects, and they will object at a later time, maybe not 2 years, maybe right away, the burden suddenly is on the relatives who have, or friends who have gotten APR on the child. Tim?
And let me just comment, we see the cases when you close them out. I mean, we see the families who come to us later on down the road with an APR or permanent guardianship arrangement and says, we want to either pursue an adoption or alternatively the birth parents have filed a motion to modify and we need to litigate that. And it's so critically important, I just want to make the point again, that if there are findings in that order of APR finding that the parents are unable to parent or unfit, then the burden of proof is not shifted to the third party, and the constitutional protections afforded to birth parents does not apply. So again, emphasizing, please put those findings in the stipulation and orders.
And then, Tim, could we talk about adoptive couple real quickly, and that is it a fair alternative interpretation of that case? That because it is a plurality opinion, and in a plurality opinion, the Supreme Court has said that the way to interpret the decision is to look at the narrowest issues, the narrowest determination that everybody agrees on. And while Sotomayor, and tell me if I'm wrong about this, seems to have the same opinion that you do, and that is that someone, for instance, in Seth's case, where the mom lied about the father, and the father happened to be an Indian person, and he came forward at a later, way late in the proceedings and said, I'm Indian, I should be able to raise my child. ICWA applies here, that person could be cut out even though it was fraud against him. But Breyer agreed in the decision, and Breyer was the one who said, I'm only agreeing with this because it doesn't deal with that kind of issue. It deals with a guy who prospectively abandoned his child. And so wouldn't a fair reading of the adoptive couple case be that it only applies in this very narrow circumstance where the father prospectively abandoned his child?
I think that's a fair reading, and I think that's why this case is going to open. There's still a lot of litigation to be done. I mean, it doesn't address fraud upon the court, but at the same time, there's a school of thought, and obviously Colorado doesn't have a putative father registry, but there is a school of thought that, putative birth fathers, just by the fact they had intercourse, have an obligation to follow up to see if they've had any children. I mean, there is an affirmative duty in some states. That's why they have a putative father registry, and they have to register to say if termination or adoption plan is ever put in place. It's their obligation, not someone else's. But I think it's a fair interpretation, and I think it's going to still be a heavily litigated case, but I think the decision still dramatically impacts how we interpret it, even that narrow reading.
In cases where there's a presumption of paternity, there's a birth certificate, or they're married, how invasive do we need to be? I mean, do we always need genetic testing?
Well, in those cases, I would still want to make sure that the birth mother wasn't having sexual intercourse with other men. Because again, obviously you're going to terminate the rights of the presumptive father, but if you don't identify other putative fathers that may have had sexual intercourse with her at that time, then again, the finality of the adoption is in jeopardy throughout.
For an infant, we should be demanding a genetic test.
I think that's an important safeguard.
Or at least inquire. I know this guy's on the birth certificate. at the very minimum, inquire if there's other potential fathers.
We, in my county, we've had an unusual trend, at least in a couple of cases, where with an infant or a toddler, the department has suggested that we just need to vest permanent legal custody with a non-relative, and I've disagreed with that and filed for termination in both of those cases and have gotten termination. And so the plan in those cases has been for the adoptive parents to seek private adoption after 12 months because the department has said they're not going to approve the adoption because of their own internal policies. How does that affect the adoption subsidy? Because I think what you were talking about was where there's an APR and not termination. Here we have termination and then a private adoption later without department approval.
Let me just go back for a second. There's a case called In the Interest of MDCM. It's a 1974 Court of Appeals case here in Colorado. And that case dealt with where the department would not provide its consent to a public adoption. And the Court of Appeals in that case said that the trial court can dispense with the department's consent and approve the adoption. So in your cases, there shouldn't necessarily be a delay between the termination and the adoption. If the department doesn't want to consent, then the argument is made to the court that their consent is no longer necessary, and there's clear authority under the interest of MDCM.
Thank you.
I just had that issue with Betsy Hoover down in the Springs, and ultimately the county came around and consented, but we had to brief that issue because that was going to be one of the issues as to whether or not the department was going to consent to this adoptive family that they kind of fell out of being in line with.
I have a couple of questions. Are adoption subsidies and benefits available in an adult adoption between 18 and 21?
No, typically the adoption sub is going to terminate at 18, although in some circumstances it can be continued to 21. So typically the answer is no.
The slide you had up there, I think, said that as long as the child is in the care of the department. So for a lot of kids, that's until 21.
In most cases, when we set up a subsidy, it's going to continue through 18, but if the child has significant developmental or emotional needs, it can be continued through 21.
And the troxel concern in the language of being unfit, if it's not there, still wouldn't there be a presumption that any change of placement is detrimental to the child?
No, again, the two cases that I cited clearly place the burden on the third party. And clearly presume that constitutional protections for birth parents exist when there's a consensual arrangement for an APR guardianship.
And I think that your slide or your comment or the opinion was that an Indian placement family needs to come forward and petition for adoption?
That's what, the way the Supreme Court interpreted the placement preferences, it said because there was essentially no other family that came forward affirmatively requesting essentially placement, then the placement preferences weren't in play.
So all they had to do was request, petition was not a legal act?
I think that's one of those issues.
Because I don't know how you petition if the department hasn't placed with you. And I don't know how you would file a petition or do a legal act if the department refuses to place with you.
I think that's where the time frame kind of plays in. I mean, in the context of the dependency neglect case, if termination occurs, you're looking at then placing with the foster parents or someone else with whom the child is placed, and at how late of a stage can either a member of the child's biological family or a member of the tribe come forward and affirmatively say we are a viable option under these placement preferences.
We'll do one last question because I think we're out of time.
We have a microphone.
I have to ask. I have kids or parents deceased. The kids are getting SSI, death benefit, from the parents deceasing. If they get adopted by the foster parent, what happens to that benefit?
The SSI death benefits will continue upon the subsequent adoption. They don't discontinue. Yep. Thank you very much.